Order, order. Welcome to this evidence session for the Home Affairs Select Committee. We're taking evidence this morning on the preparations for the 1st of January on EU security cooperation. Very grateful to have with us this morning DAC Richard Martin from the National Police Chiefs Council and Steve Rodhouse, the Director of Operations for the National Crime Agency. You are both very welcome this morning. Clearly, we take evidence at a moment of some uncertainty still, and we don't know what the security arrangements are yet going to be from the 1st of January. We all hope that there will be a security agreement in place in time for the 1st of January, but we recognise that we are asking you questions effectively about your preparations in the event both of an agreement being reached and in the event of no agreement being reached. But we are very keen to get some very clear details on the nature of the preparations that are in place and what we will be ready for, what we will face challenges from as a result. So we want to begin with questions about Europol. So go to Ruth Edwards first.
Chair, my questions are for Mr. Rodhouse. You've said that the NCA is preparing to surge additional international liaison officers to European capitals in the event of a no deal. I was wondering, what will these officers be able to do that replaces or replicates the current liaison arrangements that we have through Europol?
Thank you. Yes, good morning. Good morning, everyone. So that's right. In the event of not being able to continue our participation in Europol, we have a plan in place to supplement the international liaison officers we already deploy across Europe with a further 11 officers deployable into key countries, into our embassies there. And they will help us bolster the necessary bilateral arrangements and negotiations and information sharing that we have with those countries. So we've obviously chosen them wisely in terms of where we have the greatest overlap in terms of organised crime. But they will be there to foster good relationships, which we have already actually, with those countries, and to, as a result of those relationships, be able to share information, seek information, and where necessary, mobilise operational activity, and generally gain information which we can maybe convert to evidence, but certainly allow us to mount operations that will protect the UK.
Excellent. And would those sort of relationships on what these officers are able to do, would that fully replicate? Would we have the same level of liaison and things like that we do with Europol at the moment?
Well, we've been really clear throughout all of this that actually we really value the multilateral nature of the engagement with Europol. And clearly, organised crime is transnational. Many of the investigations that the National Crime Agency undertakes involve a number of EU member states. And one of the beauties of Europol, of course, is that you could engage with the entire organisation and share information through Europol that is applicable or sourced from a range of member states. And of course, that may not be possible in the future. So we also, it's fair to say, and we've been quite clear on this, we also benefit from some of the analytical capacity and capabilities that Europol offers. That helps us make some links between EU member states and between criminals, frankly, at times, that we wouldn't otherwise appreciate. That is difficult to replicate on a bilateral arrangement. It's not impossible. And we have good bilateral arrangements right across the world, and we find those exceptionally useful. And I have no doubt that will continue to be the case in Europe. But I wouldn't want to withdraw from anything I previously said about the value we attach to the multilateral nature of Europol and the analytical capabilities that we enjoy there.
And I think you also raised concerns that these bilateral relationships will be a lot slower and more labour intensive than the arrangement we have with Europol at the moment. How much slower? And could you give us a sort of example to bring it to life as to how this might impact on an operation in reality?
Well, that is difficult to put numbers on this. I mean, if we are looking to generate activity or to share information at the moment between member states, it's not through a Europol intelligence sharing link, we'll do it through a European investigation order that does place requirements on both us and EU member states to respond within certain times. the fallback provision that we would move to would be the use of mutual legal assistance requests, where there just aren't those levels of service level agreement, if you like. It's rather hard to put dates and times and days elapsed on this, but I think it is fair to say that Europe has benefited from the introduction of European investigation orders because it has provided some certainty that material will be provided within a certain period of time. So that's our concern. We have been clear throughout this that one of our concerns in the event of a non-negotiated outcome is that investigations could take longer. And of course, if investigations take longer, it can mean that serious criminals are not held to account as quickly.
And is that based on your experience from bilateral relations with other countries who aren't members of Europol? How do you find the relationship works there?
Well, we make very good use of mutual legal assistance requests in conjunction with the Crown Prosecution Service right across the world. But of course, it's variable depending on the states with which we're engaging. So it's a very variable picture.
Thank you very much. No further questions, Chair.
Thank you, Chair. Just picking up on similar themes, Steve Rodhouse, could I ask you first of all, to what extent have you been, in any way sort of privy to the nature of the security agreement, if any, that is being negotiated at the moment?
So we've been working very closely with colleagues in the Home Office, and we have had members of the National Crime Agency supporting the negotiation efforts. But I'm certainly not cited on the detail of any agreement. I'm led to believe that in the event of an agreement, we could be hopeful that many of the capabilities and tools that we currently enjoy might be replicated in one form or another, but certainly not all. But I'm really not privy to the detail of those. And I think clearly with negotiations ongoing, it'd be premature to speculate too much.
Could you give an example of any sort of well-known case that was completely reliant on shared data and security systems with, whether it's Europol or any kind of other shared data system?
Well, pretty much all the investigations the National Crime Agency undertakes relies on either people or commodities or data or cash flowing across international boundaries. And as a matter of routine in National Crime Agency investigations, we will deconflict our intelligence with Europol, as an example, to make sure that we are not operating on multiple states operating against the same organised crime group. So it's hard to draw out one particular example because it is part of our business as usual and will continue to be so in the event of a negotiated outcome or a non-negotiated outcome. It is
just in terms of sort of, I think one of the purposes of today's hearing is around public safety and around the question of whether or not we're going to be less safe in the future. And I just wondered if I could ask you, I suppose, to prioritise what, as an absolute minimum, you would need to see some read across in any if there was a negotiated deal, and what would be more sort of nice to have that could be agreed at a later date in a bilateral way.
Yeah, I'll certainly try to do that. So, of course, this is a motive material, isn't it, around public safety. So we've been clear, public safety is enhanced if we have fast and effective routes to share information and intelligence and to mobilise activity across Europe. And actually, public safety is supported when we are able to identify opportunities to intervene against organised criminals. Now, the current tools do that well. They're not perfect, but they do that well. So we've been really clear we want to retain those capabilities in some form or another. Our concern, and we've been really clear on this for quite some time, is that we may well be slower in the future in being able to share data, obtain information, and there is a risk that we will have less complete information in the future. Now, that's quite difficult to quantify because actually the degree to which we have more or less data is really reliant on whether EU member states choose to use in full or in part all the tools that we use. So there's been lots of conversation, for example, about SIS2, a great system that shares data alerts across Europe. Now, I'm led to believe it's very unlikely that even in the event of a negotiated outcome, we will retain access to that. And that's the way it has to be, and we'll be ready to work on alternative powers. The alternative power there is the use of Interpol alerts, a comprehensive system which we use across the world. But in Europe, SIS2 is more commonly used on the front line by European member states. And in the future, we will be reliant on EU member states, not just using SIS2 to circulate their data, but also circulate it in the form of Interpol alerts, which we can then accept and then put onto our core systems. Now, I cannot be sure of the extent to which all and every EU member state will make use of the Interpol route. It may be there is almost complete compliance, in which case the data gap will be minimal. But it is right for me to raise that the prospect that there will be some EU member states in some circumstances who don't use Interpol alerts. And of course, if the UK doesn't have access to SIS2, that provides a gap for us. I think the other area that I'm really keen to spell out, and I've done this before, is good decision-making relies on good information. Good decision-making maintains public safety and allows us to minimize risk. One of the things that is really important is to understand the background of people who you have standing in front of you or people who are in your communities. And one of the ways we do that is by understanding someone's criminal history. So access to the systems, ECRIS is the name of the system, that provides professionals within the system to understand whether somebody has ever been convicted in Europe of a serious offence, is an important piece in the jigsaw in managing risk. So I would be concerned if we didn't have swift access to that in the future. And I know that's been part of the negotiations.
Thank you very much. Richard Martin, is there anything you would like to add?
Thank you. I would concur with Steve. Of course, a lot of the systems that my officers use on the front line are the automated systems, and I think the ones that Steve's highlighted are the ones that are the same concerns for geographical policing. I think, at a conceptual level, what do we want? We want the ability to share information at pace. We want the ability to be able to respond to things fleet of foot. We want to understand the people that we may be meeting on the streets at any one time. And I think that very much fits in with the sort of mentions that Steve's been talking about.
Just as one final question, just as a read across, do you have, would these systems also have relevance for sort of immigration issues? So for example, if there wasn't a sufficient exchange of security data, would you have problems knowing when people entered the country that they were somebody who otherwise would have kind of, had a red light flashing on the dashboard or wouldn't have been permitted to enter, or is that not?
So perhaps I should answer that. So the same issues apply. So the Interpol system provides alerts which the UK takes and is able to place onto the warnings index, which is a database that my colleagues in Border Force will use at the border. And clearly that system is more effective with the more complete data it has on it. But this session is around readiness, and there has been a huge amount of work that has gone on to take Interpol notices, whether they be about people or objects, and to place them onto systems that UK police forces, officers on the street, and Border Force through the Warnings Index will be able to view and react to. I come back to the point, that system is as good as the data is put into it, but we have made real efforts to make sure that Interpol notices are available now to frontline officers within the UK, and that where officers within the UK have been undertaking investigations and they've circulated people on the SIS2 system, we have now dual circulated them on the Interpol system. So a great amount of work. Really, we should be proud of the work that we've done to make sure that the information is as available as possible.
My final question is, you create the impression that the sort of accuracy of the Interpol data is more variable than Europol. because there is sort of more variable participation by certain countries in terms of how much they register. You may not be able to answer this, but if you can, could you give the committee a sense of how much less data you think would appear on Interpol as opposed to Europol?
I sort of just want to be clear. It's not the accuracy of the data, it's just the degree to which a member state might choose to use both systems. If they're circulating information on someone who they have no reason to believe is coming to the UK, they might choose to use SIS2 rather than circulating on the Interpol notices. We did circulate, I wrote a letter in November that did provide some data on the scale of use. They're not immediately comparable because there are some things that you can circulate on SIS2 and some that you can't, and vice versa for Interpol. So I don't have numbers at my fingertips on that, but I can certainly write if it's not in the letter we circulated in November.
Thank you. That's all from me.
Can I just ask you some then follow-up questions, both on the Europol and on SIS2? The number, I'll ask you a bit further about this, the number of Interpol alerts that are available at the moment and what other countries are doing. At the moment, as I understand it, if we lose SIS2 access, the government is proposing to delete from all of the UK systems the SIS2 information on arrest warrants from France, Germany, vehicle data, that kind of thing. Is that correct?
That's right, yes.
So is it correct that that would mean losing 40,000 alerts for the purpose of arrest or surrender?
The 40,000 figure is that I recognise is where there are Interpol red notices that we will now be putting on and making available through the PNC, so they can be acted upon by the UK. There is a number, I think it is in the region of 185,000 non-UK alerts that are on the SIS system that have been incorporated into systems within the UK that will be deleted. But there's a real variety of what those alerts are. They're not all related to people.
Okay, so the breakdown, I'm going from the SIS2 2019 annual statistics. So this may not be the accurate. It says that there are 40,000 alerts for the purpose of arrest or surrender on the SIS2 database, 500,000 alerts on third country nationals to be refused entry or stay into the Schengen area, another 120,000 missing persons alerts, another 126,000 alerts on people to assist with the judicial procedure, 168,000 people for discrete and specific checks. So that's the sort of the total of the alerts on persons on the SIS2 database currently, or the broad numbers on the SIS2 base currently, as I understand it, from countries all over Europe. So if we are losing access to the SIS2 database, I'm interested in how many alerts on criminals or suspects wanted for arrest in other European countries that we will lose access to overnight between the 31st of December and the 1st of January.
So I can tell you that we have added 135,000 Interpol alerts to the PNC and the warnings index. In terms of alerts circulated by the UK on SIS2, there are 37,000 person alerts circulated by the UK, but they will be now, as a result of our work, they will be available on the Interpol systems.
So all of the person alerts that you currently put on SIS2, you have put onto Interpol?
Not everyone. This is a complicated issue because when, and Richard may well want to come in on this, but when officers across the country circulate somebody as wanted at the moment within the UK, they are automatically circulated on the SIS2 system, whether or not there is any sort of intelligence that that person may have travelled aboard. So officers across the country have been reviewing those alerts, and where there is a requirement or a need to circulate them onto Interpol systems, so that those alerts will still take effect, they have done so. And as I say, 135,000 Interpol alerts have now been made available to PNC. Richard may want to speak about the work that's going on.
I just want to clarify the difference between there's our alerts, so the people that we want to interview or to arrest and so on being put onto the Interpol system. What I'm interested in is the European alerts. How many of those, if there's in the ballpark of 40,000 alerts on the system at the moment from other European countries that we currently have access to, how many of them have now been put onto the Interpol system so that we will still get access to them on the 1st of January?
8,102 alerts earlier this week have been dual circulated by the UK.
No, I'm not asking about what's been circulated by the UK. I'm asking about what the UK will have access to that has been circulated by other European countries.
I'm afraid I don't have a number for that. That's something that is not visible to us.
Okay. So it is visible that we do know that we are going to lose access to 40,000 ballpark, to around 40,000 alerts from other European countries on people who are wanted for arrest, so suspects wanted for arrest in other European countries, but we don't know how many of those 40,000 have also been put on the Interpol database by the 1st of January.
That is correct, because it is the EU member states that own those circulations, and we have been, as you would expect, working closely to articulate the issues that we face with EU member states, and to alert them that we will not have visibility of SIS2 alerts, and therefore they should, like us, place those onto Interpol routes. I don't have visibility as to what degree EU member states have reacted to that and placed those alerts themselves.
Do you have any awareness on any country, like, for example, Spain's put around half of its cases on, or Germany's working hard to get all the cases on, or anything like that? Do you have any, even if you haven't got visibility of the details, do you have anything you can tell us even broadly about what other individual countries are doing?
I'm afraid I don't have anything that I can speak about in terms of individual countries, no, except to say that we have continued to liaise closely. And in many cases, some of those alerts will already be dual circulated. They will already be both on SIS2 and Interpol from those countries, which is why it's difficult to quantify the additionality that they have now placed onto Interpol that they hadn't already done so before. So I'm afraid I don't have any more information on that.
So you can't see how many French arrest warrants are on the Interpol system at any time?
I would have to go and check on the degree to which we can attribute alerts to individual countries and then see what additionality there has been over time. I could write back to you with that information if that would be helpful.
So you talked about uploading the Interpol information to the PNC and to the warnings index. Is that correct?
That's correct, yes.
So that's the Interpol alerts. That's the Interpol, effectively the arrest warrant information that's being uploaded from Interpol onto our computers, yeah?
That's right. That is where we have taken Interpol notices and placed them onto the PNC so they are visible to our officers, yes.
So, but if we've done that, and you've said that there are 135,000 in total, and I presume that includes both people and vehicles and documents and whatever else might be allowed on the Interpol system,
Yes.
If we've done that, surely you can see how many of those 135,000 relate to people, how many of them relate to France, Germany, other countries, surely.
So these are Interpol notices that are received by the UK, and now we have made sure that those circulations have been made available through the PNC. Yes. I'm not sure I'm following that line of question. I don't wish to frustrate.
I'm just trying to, maybe DAC Martin can come in on this. What I'm trying to understand is I'm trying to understand the scale of the capability gap. So we've been told many times that there is a capability gap between the SIS2 system and the Interpol system. We've been told that there is more information on the SIS2 system than on the Interpol system. We've been told that there's a gap and we're not really sure what other European countries are doing. I'm just struggling to understand this, because you've also told us that we are doing what sounds like a kind of almost like a manual upload of the Interpol information onto our own PNC and warning index things. So what I don't understand is why you can't tell us actually what is the capability gap between the amount of information that other European countries have put onto SIS2 and the amount that they've put onto Interpol. Because you've just been going through the Interpol information to upload it onto our systems.
Yeah, I can only repeat that we've taken 135,000 Interpol notices and made sure that they are available to UK systems.
Those 135,000 Interpol notices, what proportion of them are people and what proportion of them are documents, vehicles, other bits of intelligence?
I'm afraid I don't have that data to hand this morning, but I will certainly write to you with it.
DAC Martin, can you shed any light on what is happening in other countries and the scale of the intelligence gap between the two systems?
Not in relation to other countries, obviously, because my focus is on domestic. I can tell you what we've done domestically, and that is we've been working with forces to upload all of those people that they want and believe are going overseas onto Interpol notices so that they are visible across the world. So we've uploaded an additional 9,000 people that are of interest to forces onto the Interpol system that are currently also on SIS. So we've been very much focused on those that are critical to geographical policing in this country. In relation to capability gap, whilst I can't give you numbers, what I can give you from our point of view is just the difference in capability of the two systems. So at a very high level, what I would say is that with SIS2, if you come across a hit, i.e. any member state checks SIS and it comes up with a hit, actually there's a mandation for them to do something with that information or to carry out an act. Obviously, that's not quite true with Interpol, where that's very much a voluntary basis. So that's the sort of capability I would look at. And of course, again, as we earlier spoke, SIS is automatically mandated into our system. So if you put somebody on the system as a missing person, currently in the UK, you probably have about 220,000 people go missing a year. Straight away, obviously, that goes on to a system that 27 member states are looking at. So the officer doesn't have to worry in one respect about whether they know they're going abroad or not. It's almost like a catch-all, you know, it helps the risk assessment process. So of course, those 9,000 I've been talking to you about, now what we have to do on the more manual system with Interpol is that we have to design and have done a risk assessment to actually think through whether that person may go overseas. And as much as you'll try and do all the information intelligence you can, some people by necessity don't always follow logical rules and may go overseas. So those are the sorts of capabilities, I guess, is that we don't get Interpol live time. I think the work that the NCA have done about putting Interpol notices onto PNC is really important. But of course, there'll be a slight delay in that information being transferred across. Whereas with SIS at the moment, as soon as you enter it onto our domestic system, it is uploaded onto that system that 27 member states can see.
Okay. So, and just in terms of the practical process, if something is put onto the Interpol system, what is it that you have to do to then get it up onto the Wardings Index and the PNC?
So it is a system or process that's administered within the UK's International Criminality Bureau we have largely automated that and introduced robotic process automation to effectively take the details from one system and to place it onto the PNC. There is when we look at Interpol red notices, and I've no doubt we'll come on to talk about extradition, there is an additional layer of process to ensure that we are in a position to authorise an arrest made on the basis of that Interpol red notice. And of course, that requires a degree of automation and then a degree of human intervention to assess whether or not that particular case is appropriate for an arrest to be made within the UK under the provisions of the new Extradition Act.
And what are the time differences involved? So if Italy puts an alert on or a red notice, or actually you have to take a red notice first. If Italy puts a red notice up on 9 o'clock on a Thursday morning, at what point is it likely to then appear on the warnings index?
The warnings index and the PNC are slightly different processes, actually. So it is likely to appear within the PNC within a small number of hours, a fairly minimal gap. The warnings index may take slightly longer because it is an additional level of process and uploading on a daily basis, but it's within 24 hours.
Okay. And so that's if it was a red notice. If it wasn't a red notice, if it was just another form of information or alert, how quickly would it go on?
Similar timeframes.
Okay, and then so then just let me take you back to this issue about the volume of European data coming now onto our PNC and our warnings index. So if we're concerned about making sure that our border force staff have the information they need about suspected criminals arriving at Heathrow or at Dover and so on, then presumably we have done an assessment of the volume of information we currently have on SIS2 compared to the volume of intelligence that we have on people coming from those European countries on the Interpol system. So let me ask you again, if the SIS2 system has on it 40,000 ballpark alerts on wanted criminals, another 500,000 alerts on third country nationals to be refused entry, what then is the comparable volume of those either red notices from Europe or warnings about third country nationals who may need to be refused entry that we will have access to on the 1st of January on an Interpol system?
So it does remain difficult to give you a precise answer to that. And as I say, I do wish to help rather than frustrate. So we know there are in the region of 40,000 Interpol red notices that we need to validate on the system. So it is not, well, it is a close figure to the number. 37,000 is the latest I have in relation to SIS people notices placed by the UK. So we think actually the gap in terms of Interpol red notices versus alerts on SIS2 is relatively small, but I'm afraid I don't have precise numbers for you.
Okay. How many of those, so if there's 40,000 Interpol red notices currently existing on the system that need to be uploaded onto the warnings index and the PNC, how many of them will be uploaded by the 1st of January? Will all of those cases be on by the 1st of January?
Yes, apologies, we're talking at slight cross purposes. Yes, all of the Interpol red notices will be, indeed in many cases are, already on the PNC. We've done that work, and that's included within the 135,000 figure that I spoke to you earlier.
And on the warnings index as well.
That's right. That's right.
Okay. And then the 500,000 third country nationals who come up on the warnings index currently as people that France or Spain or others have said should be refused entry to the Schengen area. So those alerts that come up, what proportion of those 500,000 people are now going to be put up onto the Interpol database by the 1st of January?
I'm afraid I'll have to write back to you with that data. I don't have that data in front of me, and I wouldn't want to speculate.
Okay. Are those people that you are worried about? I mean, they're presumably people who have been excluded from the Schengen area or from other countries for a reason. Are they people that you are worried about not knowing who they are when they arrive at the border on the 1st or 2nd of January?
Yeah, and I understand the point. And of course, as a law enforcement professional, I would want our people to have the most up-to-date and the most accurate information to make great decisions. So clearly, understanding why people may have been rejected in or highlighted by other countries is an important source of data for the UK.
So it is a concern that we don't know who those people are or what the reasons are they might have been excluded. And the reason, and then are you unsure because you don't think this information is known, or are you unsure because you don't have this information in front of you at the moment?
Well, if it's been circulated on Interpol, we will have those that information, and it will be made available on the warnings index. I come back to my original point, and really the point of this exchange, it's around the gap between those people who may just have been circulated on SIS2, who are not circulated on Interpol, and therefore the degree to which there's a cohort of people who may come through that border that won't be on Interpol, therefore won't be highlighted to the warnings index, and therefore officers at the border. And of course, I'm not an expert on the border. Some of those questions would be well placed at Border Force, would be able to make decisions based on that. It is that gap between what we have on one system and what we will have on the Interpol system, and then PNC and the warnings index.
Okay, so there's then one final question from me on this point. At this point, then is I think I still simply don't understand why you don't have an assessment of, that compares. Here's all of the information that we can even just see by volume that's on the Interpol database from Italy, for example. Why you can't see, well, here's the number of alerts from Italy, the number of different kinds of alerts that we can compare that Italy's put on the Interpol system and Italy's put on the SIS2 system. If they were the same, actually, we'd have a pretty good idea that Italy was updating both at the same time, and maybe France doesn't. But I don't understand why you don't have that assessment, given how important this information is going to be for the 1st of January. And maybe that's because I'm misunderstanding the way the system works.
Okay. I understand the point, and I will write to you to see if we can provide some more clarity on that.
Thank you. Tim Lawton.
Thank you, Chair. I just want to take a different angle here, because everything we've heard so far has really been about the capability of the UK accessing shared information, which we won't have access to, depending on what happens after the 31st of December. But we know that the UK is one of the biggest users, if not the biggest user, of systems like SIS2, which means we place a lot of information on that as well. So what approaches and discussions have either of you had with the other members of Europol about what they won't have access to after the 31st of December in the absence of a security agreement, and the implications for them and what they are intending to do about it? Richard Martin, do you want to start on that?
Yes, thank you. I'm leaving most of the Europol question to Steve. I mean, that sits under the NCA. What I would say, there is and I think you're alluding to, there is a mutual loss of capability here, both for the UK and for the EU. You're right, we generate a lot of intelligence that we feed into the EU. If I look at other capabilities such as PRUM, which is fairly new for all of us, obviously, that's about us being able to circulate and search DNA stains at crime scenes against individuals. So the latest data on that, just to give you a picture, is that, since we went live, we've had 13,000 matches in the UK of suspects versus data stains, but actually we've had 43,000 matches from member states. So as you can see, these capabilities, the intelligence and everything else, is really a mutual loss of capability. So the colleagues that I tend to interact with, obviously from a geographical policing point of view, have a very good relationship with the foreign law enforcement community in London. So there are obviously offices that are based in immigration embassies and consulates, and they're very much aware at an operational level of the loss of the UK working with them. They are very keen to continue working with the UK and explore those sort of bilateral arrangements once they know the legal framework they can do so in. So I think, as I say, Steve's more an expert on Europol, but I think there is a general recognition with the colleagues that I engage with and from the statistics that I've just supplied to you, that this is, it's a big loss for the EU as well as it may be for the UK.
Thank you. Would you agree with that, Steve Rodhouse?
Yes, I would, absolutely. We engage through our international network as well as through Europol with EU member states, and they recognise that we make a big contribution to European security. And on an operational level, we have very strong relationships. To focus on Europol particularly, we are the single greatest contributor to their data systems. We lead, or did lead, the greatest number of their specific projects in relation to particular organised crime threats. And, we are regarded as an active and important member. So from an operational perspective, I know that colleagues across Europe don't want to lose the value that the UK adds to European security. And to be fair, we will continue to play a full and active part, whether we are able to play as full a role in Europol as we have done. But we will do that through different mechanisms, whether that be through Interpol as an organisation or other regional bodies or on a bilateral basis.
Sure. I mean, the point I'm making, it was a point that was made by Rob Wainwright in earlier hearings that we had, and obviously he played a key role in developing Europol before he stood down, that it's absolutely essential that we continue to share that information, and if we don't, that decision is purely a political decision. The technology is there. The various protocols that we need are there to share that information. It's purely a political decision to effectively switch off our access to it. So the point I'm making and the question I'm asking is, what approaches have we had from those other 26 members of Europol about how they are going to cope with this large absence of direct data input from the UK after the 31st of December, if that is the case? And secondly, as a precaution from our point of view, what discussions have the NCA had with Denmark, who obviously exist without being members of Europol?
So we've had extensive bilateral arrangements and discussions with all of the EU member states, as you'd expect, talking about cases and themes and crime types of interest, and making sure that we are able to continue to share information even in the event that we're not part of Europol. So, as you'd expect, we know we're in a good place with those bilateral arrangements, and that's really the extent of the National Crime Agency's ability to impact on that. Colleagues in the Home Office have been, as part of the negotiations, engaging with the Commission in its broadest terms. But from the National Crime Agency's point of view, it's those bilateral conversations that have assured ourselves and indeed EU member states that there is a will to continue to work closely together.
Okay, so in a worst case scenario, you are seeing no evidence that the other 26 members of Europol are not panicking that we won't be able to continue to have access to these databases and share information on the existing basis after the 31st of December, and that the real impact, if it were to come to that, and obviously we all hope it won't because the current systems work well, that the real impact will be largely one of the time it may take then to obtain and share and act on that information, rather than we're never going to be able to access it at all.
Yeah. I mean, I can't comment on the degree to which EU member states are panicking, I think was the word that you used, and communicating through the Commission into the EU negotiating team. We're just not cited upon that. I mean, I come back to the point that we started with. There is no reason at all why EU member states won't continue to share information bilaterally with the UK, and I'm confident they will continue to do so. The issue really is the value that's added by being able to bring all EU member states' material together in one place to deconflict and to operate multilaterally rather than unilaterally. You know, if I look across the operations that the National Crime Agency is engaged with, typically they involve more than one EU member state. And so, of course, the value of Europol is the analysis and coordination that that can bring. So that's the loss of capability that I would be concerned about.
I understand that, but as you say, if we've got mutual agreements and we have a reasonable expectation that those countries will be sharing information with us on a mutual basis, then we can effectively recreate that database and how we coordinate it within the UK. But
I'm not sure that's realistic, because one of the benefits of Europol, of course, is that you don't know what you don't know until you've made those inquiries and understand that actually there is relevant information spread across Europe. And of course, once you know that, you can engage bilaterally and grow that information. The value of Europol is it allows you to understand those links you didn't already know about.
no, I understand that, but the weakness of SIS2 is that we don't know what we don't know, and that the information placed on SIS2 remains the property of the individual countries, not of Europol itself, and it's entirely up to individual countries as to whether they do put that information on there at the moment, just as it will be entirely up to those individual countries as to whether they supply it to us in the future. But can I? There's just one general principle point, and then I'll finish. Do you think that Denmark is a less safe country as a result of not being a member of Europol for the last 5 years?
I don't think I'm qualified to venture an opinion on Denmark's safety and certainly its comparative safety.
Why not?
I don't have sufficient in-depth knowledge of Denmark as a country,
Okay,
so I would be speculating.
Would it not have been a sensible precaution for the NCA to have had slightly more extensive talks with counterparts in Denmark, given that they are in the most comparable position to the UK by not being members of Europol, as to how they've been able to adapt to cope with it post the 31st of December? I'm just surprised that we haven't been talking a lot to Denmark.
I know we have been talking to Denmark, as you would expect, but I'm just not able to venture an opinion as to whether it's more or less safe. I should imagine that's a subjective judgment.
Thank you, Chair.
Thank you. Before we move on to the arrest warrant, just another quick follow-up question on the Europol. The Europol information system database, what is the arrangements for being able to replicate those? As I understand it, the EIS objects, around half of them are related to counter-terrorism. So what are the arrangements for making sure that that information is accessible after the 1st of January?
I'm not familiar with the that aspect of the EIS system. As you say, that is significantly used by...
Can you add anything on that?
Oh, we're geographical. We don't own any of the European elements.
Okay. The information that I have here is that Europol also operates the Europol information system, which covers stores and queries information about offences, offenders, suspects, and other key crime-related data. And that 51% of the objects searched for in 2018 were related to counter-terrorism. And around 46%, no, actually that's not accurate. 51% counter-terrorism. No one can tell me anything more about that?
So I can tell you that's a system that we would not have access to in the future, in the event of a non-negotiated outcome.
And if we have a negotiated outcome, would it be possible to continue to have access to that if we're not members of Europol?
So I don't know whether that is technically, it sounds like it would be technically possible, but it would be a term of the negotiation, and I'm just not cited on where the negotiations have reached on that.
Okay, and if there is no negotiated agreement, is there a contingency plan for accessing that information or for sharing that information in a different way?
I'm not aware that there is. I think it will be through bilateral information sharing and mutual legal assistance requests.
Okay, thank you. Stuart MacDonald.
Thank you, Chair, and thank you to both of our witnesses again for coming to give evidence. Turning to the European arrest warrant and extradition arrangements, I wonder if you could first just remind us and update us what sort of successor arrangements you would like to see in place, what you anticipate as being likely, whether or not we get a deal, and what scenarios you are prepared for operating under. I don't know who wants to go first. Richard Martin, do you want to start?
Thank you. Yes, I would like to see an arrangement that's very similar to the European arrest warrant. I think, as members will know, that the advantages of the European arrest warrant are that it's circulated very quickly on SIS, that my officers can arrest and have a power of arrest to arrest somebody they come across who's wanted. And importantly, I guess, we can extradite or ask for extradition from countries from their own nationals. That's one of the big things I think that the European arrest warrant provides. And obviously we have a proportionality element to it as well. So we make sure that we are arresting as proportionate within our law as well as elsewhere. The contingency for that is the 1957 Convention on Extradition. The difference with that one at the moment, of course, that it's very warrant based. And I know the recent act is going through, or has just gone through Parliament to provide, hopefully, an arrest power for European countries should that become necessary. The difference with the fallbacks, especially with the 57 Convention, of course, is that countries can refuse to extradite their own nationals. And there are a number, and you've heard us quote before, such as Germany in their constitution, that would not extradite their own nationals. So that would add a complexity to us to either go overseas and prosecute should that be in the benefit, or to hope that the individual left that country at some point and we could circulate them on an Interpol notice and arrest them in another country. I think the best second, we know we're not going to get the European arrest warrant, I guess, is the first point to place. And we've been very keen, and I know the negotiation team have been trying to secure what they call the Norway-Iceland agreement, which in principle is similar to the European arrest warrant. However, it does come with that caveat that people can refuse to extradite their own nationals, albeit that it's easier, again, for my officers to come across somebody that is wanted and to actually arrest them and go through that process. So, I mean, that's the sort of thing we want. What I want is something where I can identify somebody quickly, my officers can arrest them, and we can extradite them out of the country, particularly if they're in this country again, because I'm sure if they're wanted in another country, they're probably not being any angels whilst they're in the UK, and it helps to protect our communities as well. One of the things we've done as part of our contingency planning within the ICCC is that we now have a national extradition unit that we've just formed. They went live 2 weeks ago, and the idea for that was preparing policing for any eventuality. So even if we were able to secure through a negotiated outcome a Norway-Iceland type deal, or indeed if we get a non-negotiated outcome, actually extradition is extremely complex. And what you'll find is there are some forces in the country that may only have one a year. And to try and ask people to build that expertise in such a short time is grossly unfair, and obviously adds a bit of a risk element to actually being able to fulfill the whole process. So the National Extradition Unit has gone live. They sit under the ICCC. And what we will do now, for certainly in England and Wales, is that we will be taking on all high and medium risk people that are wanted for extradition. We will have a team based up north and one down south. There are 40 officers in total that were part of that new team. And the idea is they will do all of the intelligence, the location, the arrests, any of the case papers that need to be done underneath that. So what we're doing is speeding up and becoming far more efficient in preparation for whatever the outcome that is that we get. And even on those sort of low cases, the ones that we can't get to just because of volume, what the team will do again is all of the intelligence, all of the network, all we're actually asking forces to do is actually make the arrest. So I think when I spoke to the committee before, one of my main missions that I've set the team here is that, you know, whatever we develop and whatever contingency plans and efficiencies we drive, it's all about not impacting on frontline policing and trying to take as much away from them, because obviously they're very busy anyway. So it's a very quick job.
Sure. Okay, just to drill down into some of that then, because that's very helpful and comprehensive. So either way, we anticipate there are some member states who are simply not going to extradite their own nationals. And I think in your letter to us, you mentioned, or the NPCC mentioned to us, Germany, Slovenia and Austria. Are there any more than that, do you know? And also, can you say a little bit more? Are these absolute prohibitions without exception, or are there some limits to these rules?
The thing with when you lose the European arrest warrant, actually any country can decide they don't want to extradite their own nationals. These are the only 3 countries that have come out, I suppose, proactively, if that's the right word, and have said we will not extradite our own nationals. So that leaves us with 2 choices really from a UK policing point of view. One is that we work with the Crown Prosecution Service and decide whether it is in the public interest to try and prosecute these individuals in their home countries. The second, of course, is that we circulate them anyway on Interpol, as it will be, because, of course, as soon as they leave Germany and enter into another country, then they're fair game. So we can arrest them from that country and bring them back. So it is really down to that country's choice as to whether they do it. It's the difference between the EAW providing a mandate to extradite your own nationals versus a voluntary process.
So, I mean, I think, as I understand it, in some of these countries, these are sort of constitutional provisions. So, for example, Germany, I think it would require a change to the constitution. It's not something they can just change their mind in. Are there other countries that could be persuaded, maybe, or negotiated with to take a different approach, or is it similarly a sort of fundamental constitutional provision there?
Germany is the only one I know from a constitutional point of view. My understanding is that the other 2 that we mentioned were purely their choice, if that makes sense. It would come down to negotiation, obviously, between government and that government as to whether they would move on those positions.
And in terms of attempting a prosecution in a different country, I mean, I assume that's a pretty rare event just now, and the logistics must be fairly challenging.
Yeah, it's very much down to Crown Prosecution Service decision at the end of the day. So it would be the case of, the law enforcement agency providing the evidence to the Crown Prosecution, and then all of the arrangements and the agreements are driven through the Crown Prosecution Service. So it's very rare. I don't have the full figures. I could certainly ask the Crown Prosecution Service to deliver them, but I would be very surprised if it's very many per year.
And in terms of scale then, I mean, so even just taking the likes of Germany, Slovenia, Austria, how many folk every year do we attempt to extradite from there?
So currently on European arrest warrants, we arrest and extradite about 1,300 a year, and as a sort of an average. So, and actually within that, and I guess this comes back down to that sort of mutual loss of capability process we were talking about earlier on. So for every 9 people that we arrest, 8 of those are obviously on behalf of other EU member states that we extradite back, as in, for every 9 that are arrested, so 1 for us and 8 for overseas. So actually that allows us to support, getting rid of people that we wouldn't want here anyway, but actually are wanted overseas. So you're talking about 1,300 per year.
But I'm just trying to get a handle on the loss of capability or our inability to get folk because of these provisions that prevent extradition of their own nationals. I mean, I'm guessing we could be talking about a couple of hundred people.
I think for people extraditing their own nationals, so i.e., I don't think the numbers will be huge. I think the main ones that we do, obviously, the ones that we arrest here and move out. But of course, there will be serious offences where, because we don't have the European arrest warrant, that may well be that we will have to decide on the seriousness of the offence, whether we do, as I said before, prosecute over there or hope they move about in the interest that we can bring them back here.
Okay, so the other operational side of things, as well as these exclusions, is time scales. And I think we're all familiar with the idea that the 57 convention is slower. But what about the sort of Norway-Iceland model? I think you've both said that would also be slower, but how much slower is that in terms of how it operates? Yeah, and why?
I mean, it's difficult to say because most of the delays on those systems obviously are at the back end, not the front end. So the front end, obviously, that policing is involved in is the arrest and putting the papers together for the Crown Prosecution Service then to obviously go through the court system. So I think for us, it's more of the back end of the system. And I remember last year when the CPS were talking that they thought it would delay by another, I think, sort of 50%, 60% on top of what they do now. But it's very much the Crown Prosecution's end where the delays would happen because of the court system.
Okay. Steve Rodhouse, do you want to comment on any of that?
So I agree, as you'd expect, with what Richard has said in terms of what we want from an extradition system and some of the challenges around constitutional or choice bars. Just to say, I mean, there's not a binary choice around extraditing own nationals. There's a whole range of variations there. So we are picking up that some member states would be happy to extradite their own nationals to trial, but they would want them returned to serve a term of imprisonment within their own country. So it's a sort of a sliding scale. And I just want to back up Richard's point in terms of the timescales taken. Typically, using the convention will take longer, but it will be very variable between countries as well. Echo the point that typically the delays are once the courts become involved. It's not often at the operational stage to actually secure someone's arrest and detention.
Okay, but are we talking sort of months of a difference here? I mean, they're obviously very tight timescales in terms of the European arrest warrant. Give me some ballpark figures.
I don't want to speculate, but your sense of months, I think, is accurate. A month.
Okay. And then finally, Steve Rodhouse, if I could just ask you, in your letter to us, you described an extradition system based on Interpol notices rather than SIS2 alerts as more complex a function than the NCA currently undertakes for the existing arrest warrant procedure. Maybe slightly treading back over SIS2 questions again, but can you just say briefly why it's a more complicated way to operate, and how we can try and make that work more smoothly?
Yeah, it's simply that when a red notice is circulated, and under the terms of the Extradition Act now, there is an opportunity for someone to be arrested within the country, that red notice needs to be certified, to effectively assess that it meets the right criteria in terms of proportionality and the seriousness of the offence. So there's an extra step in the process that is undertaken now by the National Crime Agency to review that. Now, we are looking to back record convert those assessments of those 40,000 warrants. Not all of them are currently done. They are available, they can be viewed, but in the event that somebody is found on the street and we identify that the red notice is applicable, there is a fast time process to allow the NCA to make that decision in live time, which is just an extra step in the process, and something that we have in place now.
Okay, thank you very much.
And just quick to follow up with JT Martin, the arrangements obviously between now and the 1st of January, if an agreement is reached tomorrow or Monday or next Wednesday, what arrangements have you got to have staff in place effectively over Christmas and the New Year in order to be able to make sure that they are fully trained up on whether it's a Norway-Iceland agreement or whatever the new extradition arrangements are? And do you have time to do that by the 1st of January?
The answer is yes, we do. The team are on their first week of live operations this week. They've just had a 2-week induction on all elements of extradition, both 57 EAW and potentially what Norway-Iceland means. So they are in place, they are operational, they're already out on the roads now, researching, housing people to arrest. So I'm very confident we're live now. We will be able to adapt to any one of those situations.
Thank you. Diane Abbott.
Thank you very much, Chair. Can you hear me?
Yes, can. Sorry, I was on mute. I couldn't say yes.
Thank you. And I'd like to thank our witnesses for giving up the time to speak to the committee. I just wanted to go through some of the information and data we will lose access to when we Brexit on the 1st of January. And I apologise in advance if I'm touching on things that you've mentioned before. The first thing, obviously, is the European Criminal Record Information System. Is it true to say that we lose direct access to it on the 1st of January when we Brexit?
Yes, it is, as it stands at the moment, in a non-negotiated outcome, yes.
But that's how it stands at the moment. And as it stands at the moment, we will lose being able to access the European Criminal Record Information System in 6 days. It's going to take 66 days.
Well, those are estimates in as much as I think they are. ACRO as an organisation runs the ECRIS system, but I think their assessment is that for non-EU requests at the moment, the average is 66 days, but EU requests we receive within around 6 days. Clearly, the 66 number might be skewed by countries across the world where it takes an awfully long time to get those results. But I think the view from ACRO is in simple terms that they feel it will take longer to obtain that data, not least because, as you say, we won't have access to the automated ECRIS system, and that requests for overseas conviction data will have to be made through the mutual legal assistance request system. And as I touched upon earlier, that can take quite some time with no mandated timescales.
So what difference would it make to crime fighting if, say, you had to wait 66 days rather than 6 days for criminal record information?
So Richard may want to come in on the impact on frontline policing. I mean, my background is also in policing. I said earlier, you make better decisions on managing risk if you know the background of people in front of you, whether those are people who you're investigating for a crime, or whether they are people who are going through the court processes. I think it is important to understand whether someone has a significant criminal history of serious offences, so that you can put in place measures to mitigate the risk that they might pose within the UK. And Richard, I sense will agree with me, but I won't put words into his mouth.
Well, but before Richard comes in, are you saying that a delay of up to 66 days will damage our crime fighting capacity?
I'm saying that it will potentially hinder our ability to understand the risk that is posed by people and to put in place appropriate measures.
And will that damage crime fighting? Because that's what the public would want to know.
I mean, we've been clear from the start that access to the ECRIS system is an important thing for us going forward to manage public safety. So, I mean, I think we've been really clear. It's something that's important in negotiations and that we would want to retain.
One more time, try and be clear now. If our access to European criminal records goes from 6 days to 66 days, will that damage crime fighting?
In the round, yes, I can see why you say that, and I've been really clear. I don't think I'm fudging this. Yeah, I don't think I'm fudging this. It's a capability that's really important to manage risk, and we want to retain it.
Can I move on to the Schengen information system? Is it true to say that we lose access to that on the 1st of January 2021 when we Brexit?
I expect so, yes.
Does your fellow witness, does he have a view on this?
It appears likely that we will lose it, yes.
And will this damage crime fighting capacity?
Yeah, absolutely. I think I've been clear to say that the SIS2 system provides good quality lifetime information to officers on the street. It allows them to understand more about the people they're talking to. It will tell them whether they're wanted. It can tell them about vehicles and objects. So I think it is a capability that we would want to retain. And as I said, we have worked hard to put a lot of that data onto the Interpol system and make it available to frontline officers, but that's not complete. And as I said earlier, it relies on EU member states making use of the Interpol systems and circulating that data so we can gain access to it. The other point there, can I just make a similar point actually, that in Europe, when the UK uses the SIS2 system to put data on, to alert people of concerns, at the moment that is available to frontline officers in Europe. It's piped into national systems. The Interpol system that we will be using in the future is not, and that in itself presents a challenge to ensure that European partners will be able to act upon UK data. So we've been clear right from the start in this, that SIS2 is an important capability and we've worked hard to mitigate the risk, but there are gaps within this, between the two systems.
And are you able to say how often, on a daily basis, our officers, our crime fighters would access the Schengen information system?
So Richard will speak on this, but it is difficult to distinguish, because if an officer, and this happens many times a minute, if an officer uses their radios or their computers or to undertake a check on the police national computer, they will actually also be checking whether whatever they are checking has got a hit to the Schengen information system. So it is used many times a day.
Yeah, but you don't know how many.
Yeah, there's a number that Richard regularly talks about. The PNC system is checked many million times a year around this. But what I just need to be clear, I don't want to mislead people. That is a check on the PNC, which automatically checks the Schengen information system. Whether the officer
I will come to the PNC. What I'm trying to establish is whether you know how often, on average, let's say, our officers and our crime fighters access the Schengen information system, let's say on a daily, maybe a weekly basis?
I think there is an annual figure which I'm searching for in my notes now. Richard may have to hand because I know he uses it regularly, but it is hundreds of millions of times a year. I think it's right, isn't it, Richard?
Richard?
If I can help, Chair. The data from 2018 was 603 million times.
That's a year.
Yeah.
And actually, to go back, with the European Criminal Record Information System, how many times a year do our officers access that?
So with that one, it's about 4,000 per week, and that's transactions coming from the UK asking for criminal records and from our overseas partners asking for the UK for criminal records.
Thank you very much. I'm now moving on to the passenger name records. And is it true to say that we will lose access to those on the 1st of January when we Brexit? Does anybody know?
Yep, unless it is negotiated as part of the agreement, then yes, we will lose access to passenger name records.
So as matters stand, where the negotiations are now, we will lose access. And how many times weekly or maybe annually do our officers and crime fighters access those?
So I can only talk about the use that the National Crime Agency makes of this. It is in the region of once a day.
And police officers?
Made primarily by counter-terrorism officers. I'm sorry, I don't have that information.
Are you able to let us have the information?
I will write to you on behalf, yes.
Thank you so much. And finally, the PRUM system, exchange of biometric data. How often do our officers or the National Crime Agency access this data?
It's not an access thing, it's the number of hits on the system, but we have been sharing DNA data since June 2019 with 11 EU member states, but they've come on tap kind of incrementally. But over that time, it's generated 13,000 matches for the UK and 43,000 matches for EU member states. That's matching DNA samples in either country or from people or from crime scenes.
So we've had 13,000 matches, and I assume that means there must have been more hits on the system. Is that fair to say?
Well, the system operates by matching crime scene stains and samples from individuals. So
I appreciate that, but clearly if they can't match the data, that's one thing. But I'm saying that there's a figure for the matches, but there must also be presumably a larger figure for the amount of times that officers tried to get a match.
Yeah, it's not done by individual officers. It's an automated system based on the scale of the DNA database in each country. So it's an automated process that will produce the match, and it's not a case of an officer applying to see if there is a match.
But it's true to say, surely, that you've got a certain amount of matches, but there would have been more hits on the system automatically, as you say.
Yeah, yes, it's a function of the scale of DNA samples taken in each country. So it's a size of the overlap, and it is significant. I absolutely acknowledge that.
And so we are going to lose access to the European Criminal Record Information System, which we access, did we say thousands of times a week? I can't, how often do you say we access it?
4,000 times a week. That's incoming and outgoing.
Thank you. So we access it 4,000 times a week. We're going to lose access to the Schengen information system, which in the course of a year we access millions of times, I think you said. We're going to lose access to passenger name records. And how many times did you say we use that, access that?
I said that the National Crime Agency makes use of it on average once a day, but Richard was going to provide details because it's a system that's primarily used by counter-terrorism officers.
Thank you very much. And finally, we certainly get thousands of matches from accessing the prime exchange of biometric data, but we're not able to estimate how many more hits that represents. So can I just say, and you are confident that losing access to thousands, over a year perhaps, millions of items of data will not materially damage this country's crime-fighting capacity?
I think you're putting words in my mouth to say that I'm confident. I've been clear from the start that these are capabilities that we don't wish to lose for the reasons we've outlined. These are decisions that are being taken, and both Richard and I lead organisations that will continue to work really hard to mitigate the impact of those across the UK. I'm providing the factual information. I have at no point said I'm confident that we can, that these things are not important.
No institution wants to lose any capacity, but what I'm asking you is, will this, losing all of this information, and I've spoken about 4 streams of information, and as we've said, it can amount to millions of items of data a year. What I'm asking you is, will losing these 4 streams of data on the 1st of January materially harm our crime-fighting capacity? And so far, you have been unable to tell the committee.
I think I've been very clear that these are capabilities that are hugely important to us, and we would not wish to lose them. People can draw their conclusions for that. I've been clear right from the start that the alternative powers and systems are suboptimal, and I think you can draw a clear deduction from that we would not wish to lose them, and we would prefer to retain them, and we hope that will be achieved by the negotiations.
But just to conclude, it's not a question of whether I draw conclusions or whether I make deductions. You are the professionals, and you are very senior professionals. That's why you're in front of this committee. And I ask you just one more time, will losing access to what in some cases are streams of millions of pieces of data a year, will that materially damage our crime fighting capacity?
Yes, it is a loss of capability that we would regret.
Okay, I've been unable to make you to say anything in your professional capacity of the harm this will do, but thank you very much.
Thank you.
Thank you very much, Chair.
We are tight for time. We do want to still follow up with some issues around the police response on the borders. So DAC Martin, I think you may be tight for time, but if you could maybe respond to some questions from Tim Lawton, further questions from Tim Lawton.
Chair, just to put Diane Abbott's pursuit of a soundbite into perspective, I'm sure you would both agree that the EU's failure to secure a security agreement will damage the EU's crime-fighting ability. But I will leave that there. Can we come to Dover and ask what arrangements there are in the event of any disruption at Dover during the first few weeks of 2021? What assessment's been made of the need to provide mutual assistance to Kent Police and the British Transport Police? Richard Barton, do you want to take that?
So I have to start with an apology, which is never a good thing. Obviously, all the civil contingencies planning is led by Chief Constable Charlie Hall. Mine is very much around tools and capabilities. So I'm afraid I'm unable to answer, but if you would like me to go away and make contact with Charlie, I'm more than happy to do that on your behalf.
I think that would be helpful, but just in general terms, what would you expect in terms of police mutual assistance? And presumably there's been some scoping of what could happen in a worst case scenario again on the 1st of January, which is going to start at borders, i.e. Dover, and at airports.
Absolutely. I mean, I'm not aware of the detailed planning, but I know there's been an enormous amount of planning done between Chief Constable Charlie Hall, MPOC, which obviously is the vehicle within the National Police Chiefs Council that will bring in mutual aid from forces. And I know they've done detailed plans on every different contingency there could be. I also know Kent's been doing some work around, delays in lorries and lorry parks and everything else. So I'm confident the plans are well honed. I'm confident the plans are in detail. But that detail I can certainly talk to Charlie Hall to get for you.
Okay, that would be helpful. Steve Rodhouse, just in terms of about how law enforcement bodies can be confident of identifying dangerous persons, particularly coming into the country post the 31st of December, and particularly if we don't have a security agreement in place. How confident are you of our capability there?
Well, as I say, we've taken steps to ensure that the Warnings Index, which is the primary tool that our colleagues in Border Force and Immigration Enforcement will use, is as up to date as possible with material that is circulated by European partners, primarily through the Interpol I-24/7 system. I'm not an expert on Border Force work, and you might want to direct questions to them, or I'm happy to make contact on your behalf. But from our perspective, from the National Crime Agency, we are ensuring that data is made available as quickly as possible. And as we alluded to earlier, there is no significant time delay in the UK translating Interpol data into the Warnings Index for use at the border.
And of course, we will have a capability to prevent people coming to the country that otherwise we wouldn't have done under the existing freedom of movement arrangements within the EU. That's right as well, isn't it?
It's certainly true to say that there are options for the UK to strengthen border security. And one of the areas that I think the National Crime Agency will benefit from is the provision of advanced freight information that provides us more information on freight coming through the border that will allow improved targeting. And that's something that we will look to use as productively as possible, as you'd expect.
Thank you very much, Chair.
Thank you. Some just very quick then final follow-up questions. Mr. Rodhouse, it'd be really helpful, I think, we'd have some further clarification on some of the numbers that I was asking you about earlier on, around the numbers of Interpol alerts being uploaded into the system and how that compares to the SIS2 numbers. And if our clerks can pursue that further, that would be really helpful, because I think we've got some discrepancies between figures that we had understood and the figures that you've given us today. And particularly, I'm interested in what information we have on the information that other countries are currently uploading in a timely basis. You did also say something about, I think, that other countries aren't using the Interpol alerts in the same way that we are. If we're uploading them onto the PNC, they're not doing the same in other countries so that they can check things on a daily basis. Is that correct?
Yeah, it's just the fact that SIS2 is the acknowledged system, which is effectively piped to frontline forces across Europe. It's not the case that every European country has access on the front line, through personal radios and computers and the like, to the Interpol data. That is variable across Europe. Some countries do, some countries don't, and some will have to make specific additional checks, and some will have it at their fingertips.
Thank you. And then quickly, on the PNR, the NPCC has said, without the legal basis provided by the PNR directive, it's difficult to foresee how such data could be shared by member states in the letter to us. Is it possible, though, to get that information directly from airlines? Are there either powers or negotiations that can take place to get that information directly from airlines?
Yes, my understanding, Chair, is that that's part of the contingency planning, that there is a possibility of getting protocols with those airlines to supply that data. And I think that's one of the things they've been working on in the background. If I could just answer one more point, if I may. My colleagues have run out to get some data for Miss Abbott. So since May 2019, there were 1,700 PNR requests made by policing.
So that's since 2007?
2019, since May 2019.
That's in 12 months?
Yes.
Yeah. Thank you very much.
Thank you very much.
So given the expectation that at minimum we will lose SIS2 access, if we don't have a negotiated settlement, there may be access lost to many of these other databases as well. It would not be correct to say then that all the types of channels that we've used in the past, we will continue to use going forward.
That's very true. I think obviously there are more channels that may be available to us in a negotiated outcome, although we don't know the progress of those. But in a non-negotiated outcome, of course, we fall back to all of those contingencies that I think we have discussed today, which are do not have the same capability and are more slower and more bureaucratic.
So it's not the case that we'll be able to use all of those channels going forward?
In a non-negotiated outcome, no.
The reason that I ask, and it was probably slightly unfair for me to do so, is that those were the words that were used by the Home Secretary this morning. And she did say on a radio interview this morning that all the types of channels that we've used in the past, we will continue to use going forward. So that would suggest that there is a discrepancy between the Home Office's assessment of the situation and your assessment of the situation.
Yeah, I'm afraid I didn't hear the Home Secretary's interview this morning. When I say we won't have access to the same, we certainly won't have access to the same tools in a non-negotiated outcome, because of course none of those European tools will be available to us. We will have contingencies where we can have a capability within those arenas. And in a negotiated outcome, we know we're not going to get the European arrest warrant, but we may well get Norway, Iceland. So as you can see, those specific European tools, we will not have access to all of them, no.
I know that you have made your views clear to those involved in the negotiations through the Home Office and through other channels throughout this process and throughout all the detailed negotiations and talks. Have your counterparts in other European countries also made clear their views to other European governments and to the European Commission?
In the conversations I have had with senior colleagues from other law enforcement agencies, I would say in the majority, yes. But of course, some constitutions are different in how much I would suggest they're listened to by senior policing officers. I mean, as you know, we have a very good relationship here with government, and I think throughout this process we have been listened to in the things that we want. But I know that may not be the same or have the same influence depending on how certain countries are set up.
And I obviously would not expect you to have any assessment of the wider trade of issues that are at stake in terms of the negotiations. But just in terms of the security arrangements, have you also put forward representations that were there to be a failure to agree on issues around trade or fisheries and so on, that there should still be some kind of fallback security agreement in place?
We would like that very much, but my understanding is, of course, that's being driven by the Commission, that they will only accept one negotiation. And in an ideal world, I think both government and we would like to separate the two, because, you know, the impact is not just felt within the UK, it's going to be felt across Europe for all the reasons that we've said today. So I think in an ideal world, you would want to separate the two, but I think the lack of separation is not down to the UK.
If we end up on the 1st of January with no security agreement in place, either as part of a wider trade agreement or as a standalone security agreement, do you believe that the negotiators on both sides will have let down the people of both the UK and across the EU in security terms?
I think that's a very difficult one to answer without having been in the room and seen the amount of effort going into it. I would hope that there will be a negotiated outcome. I would be very candid and say that with a non-negotiated outcome, you know, it makes policing more difficult. There will be more risk involved, and we would hope that you know, people can come to a point where they can seek an agreement. But I don't think I could be in a position where I'd say they've let us down, because of course I understand negotiations are very complex.
Mr. Rodhouse?
I agree with Richard's assessment there. It's a very difficult set of negotiations, and for those of us not in the room, it's hard to critique.
And do you have any final, I suppose, requests in terms of those negotiations, in terms of making sure that security is taken very seriously as part of those negotiations?
Absolutely. We've made that clear all the way along that security is important. I agree with Richard's sense. I think we've been listened to both by the government and the negotiating team, and we watch the rest of the negotiations with real interest.
And can you tell me finally, how many additional staff will you have working between now and the 1st of January in order to ensure that any possible needed preparations are in place by the 1st of January?
So we have taken steps. We have restricted annual leave, and on any one day we'll have between almost 20 or 40% more staff than we did this time last year, in recognition of the challenges that we are preparing ourselves for, some that we can predict and some that we can't.
And DSE Martin?
So the ICCC, the new National Extradition Unit, will be working 24/7. There won't be any leave. They will be here in place, ready to deal with any eventuality.
It would be very helpful if you could let us know just the numbers of additional staff that will be working through the next couple of weeks as well. Can I then just pass on our thanks, our huge thanks to all of those police officers in working across the country who will be working so hard over the next few weeks in order to make sure that all possible preparations are in place for the 1st of January, after what I know will already have been a very challenging year for policing in terms of the other pressures and so on that we have had to face. So please do pass on our thanks, and also to your own teams who I know have been working hard. We'll just conclude with a personal view that I think, given how hard you have been working on this and given how clear you have been about the security issues that are at stake, I think negotiators will be letting you down and will be letting people across the EU and across the UK down if they cannot at least secure some kind of security agreement in time for the 1st of January. But thank you very much for your evidence today, and thank you for your work over the next coming weeks. That concludes our evidence session today. Order, order.